you.
Thank you, Madam Council.
Okay. Ms. Macariello, could you please state and spell your name for the record?
Sure. Catherine Macariello, Catherini. Last name is Maciariello.
And Ms. Macariello, are you familiar with the Atlanta Public Library District?
Yes.
Have you been involved with that organization?
I'm the director of the library.
Okay, and can you please briefly explain your job duties as library director?
Sure. I share responsibilities with a counterpart who takes care of the museum. I take care of the library. And that job includes managing the collection, adding books, disposing of books, running all of the programs that we do each year for the public, preparing all the documents for board meetings, interacting with the public, working on policies, et cetera, representing the library to the community.
And how long have you held this position?
I've been director since 2014. Prior to that, I worked as program director. So I just did the management of programs for about a year before that.
Okay, so you started working there roughly 2013.
Yeah.
Okay. Now I want to ask you a few questions about the Union Hall building. Are you familiar with the Union Hall building?
Yes.
What is that?
Well, the building is at 114 Arch Street. It's catty corner from the library and adjacent to our museum.
Okay. So that's a building in downtown Atlanta,
right.
Yeah. And you briefly alluded to this, but what is the Union Hall building been used for?
Well, when I first became involved with the library, it was an office building, and then as we moved into the Live and Learn project and this recent project, we began using the building for library programming as well.
Now, has the library leased the Union Hall building?
Yes.
Do you know from whom?
We leased first from, I think, Stone Mission. John Yates is the name of the proprietor of that company. I think we leased from him for 3 months, and then we leased for 9 months from Teleologic Learning Company.
Okay, and do you remember when that lease started?
Let's see, with Teleologic?
Yeah, yes.
I think December of 2016,
okay.
I believe.
Okay. And do you know who the owner of Teleologic was at the time?
Yeah, William Thomas.
Okay. And that's the Mr. William Thomas that serves on the Board of Trustees,
Yes.
right? Okay. Now, based on your personal knowledge, serving as library director, did you believe that there was any problem with the library leasing the building from a company controlled by Mr. Thomas?
No.
Why? And could you just please explain why that was?
Well, before we went into this arrangement to either purchase or lease the building, Mr. Thomas actually was concerned, or not concerned, but wanted to make sure that it was all fine to do since he was on the board. So he had contacted our lawyer at the time, Phil Lenzini, to get an opinion about that. And we received an opinion from Mr. Lenzini that it shouldn't be a conflict provided that he followed some rules. And this was consistent with my experience in working in nonprofits over the past number of years. So we went with the information we received from Mr. Lenzini.
Okay. And do you happen to remember what Mr. Lenzini specifically told Mr. Thomas to do?
He told him that he would need to disclose ownership of the building, that he would need to abstain from any discussion, not participate in any discussion around the lease or purchase of the building, and not to vote on anything that was related to the building.
Okay. And based on your personal knowledge, did he do that?
Yeah, absolutely.
He did all three of those things?
As far as I know. In fact, he stopped even coming to board meetings so as to avoid any perceived conflict.
Okay. So did you ever become aware that perhaps Mr. Thomas might not have, there might have been a conflict of interest in what Mr. Thomas was doing?
Well, initially, there were questions raised by members of the community, I believe, in July and August, at our July and August board meetings in 2017. And at that point, we really just let people know that we had the opinion from our lawyer that as long as, Bill did those three things, that we were in compliance and it wasn't a problem. We continued to believe that until, probably close to the end of September, I think, when August 22nd, we got a FOIA request from the state's attorney. And then on September 29th, the state's attorney, Jonathan Wright, wrote a letter to our attorney outlining concerns about conflict of interest. And that's the first time, beyond just general questions and comments, that anything authoritative was said to us about potential conflict of interest. It was really September
Who has that letter?
29th.
Ma'am, who has that letter?
I'm sorry, who has?
Who has the letter? You said Mr. Wright wrote a letter to you folks. Where is that?
Do we have it here?
You have that
I mean, I have it in my possession at the library. I don't know if we have it here.
Mr. Laurel, was there a request made for correspondence between the parties? By the Secretary
This
of
was a
State?
letter from the state's attorney to,
I understand. I'm asking Mr. Laurel if he had requested documents that would contain
The
that.
general counsel asked for documentation explaining the arrangements in the agreement. I don't know whether it was disclosed until today.
yeah, and this letter that came was the letter from the state's attorney to our attorney after basically establishing that Mr. Lenzini was the attorney of record, that he was indeed representing us, and outlining his concerns about conflict of interest.
And just to be clear, this was September and October of 2017.
2017.
2017.
Yes.
So this past September.
Yes.
Okay. Now, after you learned that perhaps there might have been a conflict of interest, can you please explain what the library did after it learned about this?
Okay. Yeah, as soon as we saw that letter from the state's attorney to Phil Lenzini, our board president decided to actually meet with the state's attorney to try to get a better idea of what if any, our vulnerability was. And so on October 4th, I believe, he met with the state's attorney and came back from that meeting feeling that this was something that we should take care of. And so at our subsequent board meeting on October 12th, we actually rescinded the original motion to purchase the building, and we ceased making lease payments. And in that same period of time, Mr. Thomas had notified our president that he would donate the building, and that announcement was made at the same meeting. And we did that to make sure that even though we had rescinded the intent to purchase, that we were maintaining continuity of ownership of the building, because that was part of our grant requirement.
And do you remember when this donation occurred?
The announcement was made on October 4th that it happened, and the paperwork was prepared during the next month, and the donation was made at our board meeting on November 16th, the presentation of the deed to the building.
So this was made right after you learned from that there might be a conflict of interest, right?
Right.
Okay.
Yeah, I mean, it really was from the 29th of September to October 12th.
Okay. So it's fair to say that the library acted very quickly to bring itself into compliance with the law. Is that right? If
So,
right. Okay. Now, Ms. Macchiarello, are you familiar with a meeting that the representatives of the library might have had with the Secretary of State's office toward the end of 2017?
Right. After we had received, I think on October 23rd, a letter from the Secretary of State's office telling us to repay the grant. And then because that letter came after the donation was announced and just around the same period of time, we asked for an informal meeting with the Secretary of State's office so that we could inform them of that prior to requesting a formal hearing. That meeting was held on December 4th.
Okay. And at that December 4th hearing, did the Secretary of State ever say anything about the library's potential violation of the act, specifically whether it was done intentionally or not?
Well, they, in the letter, the follow-up letter we got reiterating that we needed to repay the grant, they did say to us that they believed that we didn't do anything intentionally to violate the Public Records Act.
Could you please open up that book there to exhibit number 7?
Gosh, I'm gonna need my glasses.
Oh.
Yeah, okay.
Okay, can
Yeah, I
you
can see.
you can read? Okay. Is that letter you're referring to?
Yes.
Okay. Now, Ms. Macchiarello, I want to briefly discuss what the repayment of the Live and Learn construction grant would do to the library district. Now, as library director, are you familiar with the library's budget and finances?
Yes.
Okay. And how much money did the library receive for the Live and Learn construction grant?
$25,000.
And what were these grant funds used for?
Specifically for renovation of the Union Hall building in order to make it practical for our programming use.
Okay. And do you know specifically what was done with it?
Yeah, what we've done so far is open two doors. The building is adjacent to the museum, which was one of the reasons we wanted to use this building, because it's a natural addition to property we already own. So we made 2 doors, one downstairs and one on the second floor, to connect the 2 buildings together and to make it handicap accessible. We also did extensive roof repairs and some tuck pointing that we discovered needed to be done at that same time, and we repaired a back door to the building and did some renovation on a room that we use for activities and exhibits there.
Okay. And has the library used all of this grant money?
Yes.
Okay. So all $25,000 of this grant money has been spent. Okay. And has the library relied upon the grant in terms of its planning and budgeting?
Well, it's not a direct impact on our budget because they're not operating funds, they're capital funds. But it certainly we relied on the grant money to help create the space that would allow us to expand our programming, and that does have an effect on our budget and our activities.
So would the library suffer a hardship if it were required to repay the grant?
Absolutely.
Can you just briefly explain why?
Well, you know, we're really small. I mean, our entire budget is, $180,000, and most, a good portion of that is from tax revenue. It takes us a long time to save $25,000. In fact, I think we have CDs of about $15,000 right now. The other money that we have set aside is money that was received in matching funds for the grant. So I think, we feel morally that if we have to pay the money back, we need to ask those donors if they want their money back as well, which is $30,500. If they want their money back, then we don't have enough money to pay the grant back. If they allow us to use their money and we use some of it to pay the grant back, the unfortunate thing is then we don't have any money to finish the project, and there's still you know, the total project cost was about $62,000, and we still have work that we plan to do, and we won't be able to do that, hence we won't be able to do all the programming, and we'll have to go back to trying to put aside a little bit of money each year to save up. So it, you know, it has hurt, and obviously it's hurt our operating budget this year because of all the added expenses surrounding everything.
Sure, sure.
Legal fees and all kinds of, you know, stuff like that. We've already had to put freezes on purchasing materials. We may have to be laying off staff for a while, you know, depends.
Okay. So
What we have to do to come up with $25,000.
right. So the library would be able to basically just keep the lights on, and
Yeah,
that's
it
about
is.
it if it had to repay the grant. Okay. No, I just wanted to return to something briefly. You said before, you noted that the library was leasing the Union Hall building. Has this lease ever been found to be void, to your knowledge?
Well, when we met with the Secretary of State's office, that was sort of the premise, that when we made the grant, I mean, it was part of the grant, that because there was a conflict of interest, that meant that the lease would have been void. We didn't ever have any knowledge or any indication from anybody that the lease was void. I mean, we continued to behave as if it were legitimate and active, and we never had any, I mean, I think as late as August we had an extension of our grant, so we really never had any indication that things weren't going along as we planned
Okay.
that they should.
Okay. All right. That's all I have.
Okay.
Thank you, Council. Ms. Laurel?
Your name is pronounced Macchiariello?
Macchiariello. Pretty good.
Beautiful. All right, so you've been employed by the library since when?
Yeah, as director since 2014, July of 2014, and then the year
So
before.
you were director at the time that you submitted the grant application, and that was in December, January of 2015, correct? That's 14, 15. And isn't it true that you knew that Mr. Thomas owned the building at the time?
Yes.
And I think I heard you say that before you submitted the grant application, you checked with an attorney as to whether it would be legal.
No, no. That was in 2016. I believe I didn't do that. That was, I think, the email that we received from Phil was from 2016, I believe.
Okay, so several months, almost 2 years after
Right.
you submitted the grant application.
Yeah.
And was that your first inkling that there might be something wrong? Or did you?
I didn't. I mean, honestly, we didn't think that there was anything wrong at that
Really?
point because Mr.
Hold on a
Lin-
second, hold on a second.
Yes.
Mr. Thomas is a member of the board and your
Right.
treasurer.
Right.
He owns the building.
Right.
Your original agreement was to buy the building from him, correct?
Correct.
You didn't see any problem there, none
No,
whatsoever.
because-
Objection asked and answered. She said she didn't see any problem with it.
Is that correct, ma'am? I want to be clear.
Absolutely, because
Okay.
we felt that it was completely transparent and we were abiding by.
And you said that questions were raised in the community?
Community at our July and August board meetings in 2017.
This is members, these are members of,
the community raised a question about conflict of interest, and that
so
was
it wasn't
really
clear to
what-
them, was it?
Mm,
Would you describe
not.
their questioning as outrage?
No,
Were they angry?
I think it varied from questioning to angry.
Okay. Now,
Counsel.
you,
For a rule, your council's objection.
Okay.
You're seeking clarification.
initially you were going to purchase the building from Mr. Thomas. Then someone brought up the idea, or maybe someone from Stone Mission told you that they would purchase the building from Mr. Thomas?
They didn't tell me, they told Mr. Thomas.
Okay, because you said that you were leasing the building from Stone Mission, but originally you were to purchase it from Mr. Thomas.
We were.
Then it became a lease from Stone Mission.
Correct.
Stone Mission was to buy the property from Mr. Thomas.
Right.
That fell through at some point.
Right.
And so then you went back to leasing the building for Mr.
Correct.
Thomas. Okay.
This was all reported in our reports, our grant
Uh-huh.
reports.
Uh-huh. Now, you mentioned this letter from I guess, Mr. Lenzini to Mr. Wright, the state's attorney in Logan County. I guess the state's attorney's office raised these questions with you
Yes, the
on
state.
behalf of the citizens of
I
Atlanta.
assume so. Yeah.
Okay.
We received, as I reported earlier, I think, the letter on dated the 22nd of August. It was a FOIA request from the state's attorney. And then on September 29th, he wrote a letter to Mr. Lenzini, to which Mr. Lenzini prepared a response once again.
That was never sent, correct?
That was never sent, because that was the time we
Excuse me,
decided.
Madam Counsel, I rule that was inadmissible. If you're gonna go ahead and open the door to it, then I'm gonna allow both parties to inquire.
Yeah, I believe
on this
that they
witness.
asked Ms. the
Then
witness
we'll
some
just open
questions
the letter
about the
for
letter.
inquiry by both parties.
Okay, the letter was never sent.
Correct. No, because by that time, we had already received the notification of the building being donated.
So, Mr. Thomas told you he was gonna give it to you?
Objection. What do you mean by you?
What was the question?
Ma'am, you
Mr.
said you had
Laurel-
received
Mr. Laurel,
you had
no.
received
Mr. Laurel?
notification.
No,
Hold on a second, hold on a
Ma'am,
second.
sometime, there was an objection by, what was your objection, counsel? I wanna make sure I get that.
Sure. The objection was form.
Okay. Overruled. Go
Okay.
ahead, Mr. Laurel.
Did you not say that you had received notification, or we had received notification that the building was going to be donated?
Mr. Thomas notified our president that he planned to donate the building, and our president announced that at our October 12th board meeting.
Okay, and that was done in this gift deed was issued on 16 November 2017. This is, let me show you what's been marked as Secretary of State Exhibit number 13. That's a photograph or a copy of a photograph of the building, correct? And is all that the Union Hall building, or is
This
part of it?
This part right here.
And the other part is the museum?
The other part is called the Downey Building, and it houses the museum.
And is this an accurate representation of the floor plan of the building? First and second floor, is that right?
Yes. Looks to be the
Now, is that just the Union Hall building?
That's just Union Hall building.
Now, these open spaces here on both floors, those are open to the public? Anybody can go in?
Well, they're not open to the public right now because we haven't finished the implementation of the grant. They're open to the public when we host an event there and invite the public in. But
Okay, so the public has to be invited.
at the moment, because, like I said, we haven't finished the work, that will enable it to be staffed and ready and functional as program space.
All right, and does Mr. Thomas still have an office on the second floor?
Okay, objection beyond the scope. We never went into Mr.
I can
Thomas's
call her as a
office.
witness and get her to answer the question, or we can just let her answer the question.
Go ahead. I think it's relevant overruled.
Ma'am, is Mr. Thomas' office on the second floor up here in the, it's called the office space area?
Currently, yes.
Okay, I don't think I have any questions.
We concluded, Mr. Laurel.
I don't have any other questions.
Counsel, redirect.
Okay. Ms. Macchiarello, I just have a couple questions on redirect. You noted that Mr. Thomas leases space in that building. Is that correct? In the Union Hall building, is that correct?
Does he lease space?
Yes.
Currently, no.
Okay.
Because, because we was determined by our attorney that that would be conflict, so he doesn't lease space.
Okay. And do you know, are you familiar with the Logan County Economic Development Board?
Yeah,
Okay. And do you know whether Mr. Thomas has a position in that?
yes, he does.
Do you know what that position is?
I'm not sure what the title is, but he's like executive director.
Okay. And does he have an office in, does the Logan County Economic Development Board have an office in the Union Hall building?
Well, Mr. Thomas works for them, and that's the work he does in that office.
Okay.
So
Okay.
it is for them.
All right. Okay. I have nothing.
Ma'am, you're aware of that Mr. Thomas owns a business called Teleologic or something like that?
He did. I don't know the status, honestly, of that.
And isn't it true that
LLC.
that the Teleologic office was in this building as well?
It was up until the point that the building was. I mean, honestly, that timing I don't know. He did have an office in that building at one point.
Very good.
Under that business.
Very
But
good.
I don't know when that business ceased to be teleologic.
Okay, very good. Thank you.
Thank you. Anything further, Counsel?
No, Mr. Foreman.
Thank you. Thank you, Matt. Does either of you have any additional questions or anticipate calling this young lady back?
I do not. No.
And ma'am, they don't plan. Mr. Laurel, do you so you're welcome to stay, ma'am, if you wish.
Okay.
But you are.
Thank you for testifying.
Okay.
Thank you.
You can stay.
Okay. Did we want to go into closing arguments then?
If you're finished with your evidence, the Secretary of State doesn't have any other evidence to present,
Nothing, Mr.
other than our exhibits. I believe we've moved the admission of the
Have you
exhibits.
concluded your testimony then, your witnesses?
Oh, okay. I'm not sure. Mr. Warren, do you remember whether this was admitted into evidence, the October 12th? That was not one of our exhibits, but, actually I don't have a copy of it. Okay, so it looks like that was admitted into evidence. Okay, we have nothing more to introduce into evidence. Rest.
You understand?
Yes.
Mr. Laurel, anything, any rebuttal, any cross-examination, any witnesses?
No.
Nothing?
Nothing
Thank you,
other than
sir.
our exhibits.
Thank you, sir. All right. Counsel, you wish to make a closing statement then?
Yes, Mr. Foreman.
Please proceed.
So I want to jump right into addressing their point that there was no contract that existed between the secretary and the library for the Live and Learn Grant Funds Agreement. Mr. Foreman, I just don't believe that this is the case. This is a clear case when promissory estoppel existed to create a contract between the library and the state for the provision of the Live and Learn grant. And I can provide you a brief of this with this case law if you like, Mr. Foreman, but promissory estoppel exists to enforce promises that do not meet the consideration requirement of a contract. To establish a claim based on promissory estoppel, a party must allege and prove, one, that an unambiguous promise was made to that party, two, the party relied on this promise, three, this reliance was expected and foreseeable, and four, the party relied on this promise to its detriment. Mr. Foreman, each one of these four factors has been established here to show that promissory estoppel created a contract between these parties. Clearly, the library relied on the promise to receive these grant funds. As both witnesses testified, they set about their whole budget and their programming goals on the receipt of these funds to renovate the Union Hall building, which was going to provide an integral part of the library's purpose and mission going forward. Clearly, there was an unambiguous promise made here by the secretary to the library. I mean, there was a grant agreement. The money was given. As I mentioned before, the library relied on this promise. This reliance was certainly expected and foreseeable. The secretary wouldn't have provided the grant if it didn't think that the library was going to rely on it and use it to benefit the public. So this is a case where promissory estoppel exists to create a contract between the library and the state for the provision of these funds. And as a result of that, a creation of the contract, the common law contract offenses that I mentioned earlier, including the ability to cure a breach, apply here. So just to go over our argument again, there are two bases for why the library should not have to repay the grant funds. First of all, there's no evidence that the library ever violated any of the grant funds terms. They haven't proven that their theory is correct, that the lease between the library and the Union Hall building was void. I mean, they've provided no evidence that this lease was ever voided. They've provided no evidence that Mr. Thomas was ever convicted of violating the Public Officer Prohibited Activities Act, or that anything was done to void this lease. So their entire theory just doesn't wash, Mr. Foreman. The library has done everything it has been required to do under the terms of the grant. It has maintained a long-term lease and ownership of the building. Again, going into some of the law as to why the library had the legal right to cure its breach of the contract, as I mentioned before, even if they did prove that the library its agreement with the Union Hall building to lease it was void, the library clearly cured it. There's a case that I referenced in our response to the motion for a bill of particulars. And that case is entitled Stanley Yudka Sales Co. versus Lacey Forest Products Company, 915 F2 273, 7th Circuit, 1990. In that case, the court noted that a party has a right to cure a material breach of a contract, stating that an opportunity to cure in circumstances similar to the case, this requirement comports with general contract theory, and we agree with the district court's decision imposing this requirement on the non-breaching party. Additionally, the right of a non-breaching party to cure a material breach of a contract has been recognized by the Second Restatement of Contracts, and this is all explained in my response to the motion for the Bill of Particulars in more detail.
Which, counsel, I don't have a copy of that.
Oh, okay.
I have the
it's part
response
of
to the admission of facts, but not the...
Okay, yes, and this is the case law I'm referring to in particular, right there, yes. So not only does the Second Restatement of Contracts note that there's a right to, a party has a right to cure a breach of the contract, and the Second Restatement of Contracts is notable because Illinois courts customarily follow the Second Restatement of Contracts. A number of other secondary sources recognize the right to cure a breach of a contract. Farnsworth on contracts, Corbin on contracts. And some of the things, a party has a right to cure a material breach of a contract when that breach is not total, substantial, and defeats the object of the contract. Here, as I mentioned before, if there was a breach, it was certainly not total, it was not substantial, and it did not defeat the purpose of the contract. The grant funds were used to renovate the building. The library worked in good faith to cure any potential breach of the contract terms that might have existed. Right after finding out that the secretary wanted them to repay the grant funds, they donated the Union Hall building to the library. So the library now is satisfying the requirements of the Live and Learn construction grant. Mr. Thomas resigned from the Board of Trustees. So they acted swiftly to cure the breach of contract. Good faith is another one of the defenses that has been recognized as relevant to determining whether a party cured the breach of the contract. And finally, Your Honor, or Mr. Foreman, I just want you to keep in mind here that the Atlanta Public Library is a small library. It has a small budget. $25,000 is a lot of money for it. It did not purposely do anything wrong here. It was put in this situation, frankly, by bad legal advice from its former attorney. And it's not fair to either the library district or the residents of Atlanta that it be prejudiced more than it already has been by being forced to repay this grant. So that's all I have.
Thank you, counsel. Mr. Worrell, did you have any summation?
Yes, please. The library district did not ask for legal advice until well after they had filed the application and recognized that they were in trouble. They made an application, and it's the application, the documents regarding this application that are in evidence, which establish the four corners of this proceeding. Promissory estoppel and the Second Restatement of Contracts has nothing to do with this proceeding. There is no contract between the Secretary of State and the Library District. They filed an application, and the Secretary finding without knowledge that part of the agreement involved this sweet deal between Mr. Thomas and the Library District, granted them the money. It's kind of like a person goes to the Secretary of State's office and files an application or makes application for a driver's license. and then they get the license because they've done what they need to do, like pass the test, and then later they violate the law. They're convicted of driving under the influence, and their driving privileges are revoked. Same thing here. The library district violated the law from the beginning, entering into their contract with Mr. Thomas, knowing that he owned the building they were going to lease or buy from him while he's a member of the board. The legislature did not intend for the restatement of contracts to be a part of this scheme, the legislative scheme. I mean, there's nothing in the law, or the Act, the Public Officer Prohibited Activities Act, which suggests that the restatement of contracts should be considered in deciding whether there was a violation of the Act. There's nothing in the Act about some promissory estoppel. The plain language of the Act takes precedence, as does the plain language of the application. Section 3 says, no person holding any office, either by election or appointment, under the laws or constitution of the state, may be in any manner financially interested directly in his own name or indirectly in the name of any other person, association, trust, or corporation, in any contract or the performance of any work in the making of a letting of which such officer may be called upon to act or vote. Any contract made and procured in violation hereof is void. Not may be void, may be voidable, will be void, is void, as the General Counsel stated ab initio. From the moment the agreement was entered into, the contract was entered into by the library district and Mr. Thomas, it was void because he had an interest, an economic interest in the contract, and he was a member, an officer of the library district. Perhaps the most important language in the statute is in section 3.1. This section shall be liberally construed to accomplish the purpose of requiring the identification of the actual parties benefiting from any transaction with a governmental unit or agency involving the procurement of the ownership or use of real property thereby. People of Atlanta knew there was something wrong when they found out about this, and then the library figured it out on their own. Whether they had any intent to violate the law is irrelevant. The statute does not say anything about there having to be intent. The act occurred, and from the moment the contract was signed, it was void because it was illegal. Because Mr. Thomas, being an officer of the board, had a financial interest in the contract. That's all that's involved here. Thank you.
Thank you, Mr. Hall. Response?
In terms of in terms of a response, I mean, I think the case law speaks for itself. Promissory estoppel exists to create a contract here between the parties, and they haven't proven that the lease agreement between the Union Hall building and or the lease agreement for the Union Hall building was void. I mean, that's the thing to take away here. They have not proven that the lease agreement for the Union Hall building was void, so there has never been a breach of the grant terms. That's all. Thank you.
Gentlemen, this matter is concluded. Can I get something out as quickly as possible? Mr. Giussiano, you had mentioned earlier if either party wishes to send me law, that's fine. I don't expect it.
Okay.
I probably don't need it, but having said what you said for many years, if you want to send something, go ahead.
Okay.
Thank you.
I might take you up on that. Thank you.
Thank you. you everyone
Thank
for
you.
attending.